Well, welcome back, everybody. I'm Zachary Harris. I'm an attorney in Winston-Salem, North Carolina. I'm a civil litigator, and today I'm going to be taking a look at a classic scene from The Office. I've seen this scene before. It's a ton of fun, but there's also a lot of interesting truths in it about the legal process and also some things that are just completely wrong. So let's take a look, and I'll just give you my thoughts as we go through it together.
How long have you known the plaintiff?
I haven't actually seen it, but I have seen the firm, and I am planning on renting the Pelican Brief.
That's a reference to, I guess it's John Grisham, who's this author that does all sorts of lawyer-based books, and then I think they all get turned into movies.
And you were directly under her the entire time?
That's what she said.
Excuse me?
That's what she said.
Ms. Levinson told you that she was your direct superior?
What? Why would she say that?
Can we just move on to another question?
No, wait, I don't understand who's on record as saying this.
With all due respect, I'm in the middle of a line of questioning.
This happens. Lawyers have a tendency to ask questions that can be very unnatural. They're very convoluted. We tend to not speak the way that normal people speak for some reason. Good lawyering is to not do this, is to ask questions that are natural, the witness can understand and that the jurors will be able to understand. But I've definitely had situations where I've asked a witness a question and they have answered it in the way they understand it, but that's not actually the way I was asking the question. And this type of confusion happens, and it can be pretty difficult to get it cleared up. We'll see in a minute that there's a court reporter who is taking everything down, and that is the record that really matters, what's written down. So when you're doing a deposition and you have confusions like this, you have to think to yourself, how is this going to read on the record when the judge or at trial it's being read to the jury? How are they going to understand what's being said?
What did you say Ms. Levinson said regarding your employment status with respect to her corporate position?
Come again? That's what she said?
Okay.
I don't know what you're talking about.
If I may.
So interesting there, Michael, he does it as a joke because he can't help himself, but he's asking for clarification on a question he doesn't understand. That's good practice. That's advice I give my clients before they're about to be deposed. If the lawyer asks you a question that you don't understand, it's okay to ask for clarification. And in fact, you should ask for clarification.
If I may, he was just telling a joke before, so can we move on to another question?
Are you sure?
Yes.
So Jan jumping in here, that is not normal. In most depositions I have been a part of, there's not that many people in the room and there's usually no parties in the room. So Jan's the plaintiff in this lawsuit. She's the person that's bringing the lawsuit against the company. I almost never will bring one of my plaintiffs along to a deposition. Basically for this reason, is they will jump in and they will want to interrupt. They will want to contribute. If it's an adverse witness, they may want to try to argue with the witness. We can't have that. And so I will often not invite my clients to depositions, and the defense is usually the same. I won't talk in a minute about all the people in the room because there's people that belong there and there's some people that don't belong there. Generally speaking though, the only people that are gonna be in the room are the lawyers, the court reporter, maybe a videographer, and the witness themselves. Depositions tend to be a relatively small affair.
Can you go back to where this digression began?
Mr. Schneider, and you were directly under her the entire time. Mr. Scott, that's what she said.
So that's a court reporter. She is taking down everything that's being said in the room and is going to create the official transcript. This is a common thing that you see in movies and TV. You'll see the court reporter read back what was just said on the record. I've never seen that done. In fact, I'm not sure it can be done nowadays. A lot of the court reporters that I use will take note of what's being said through a dictation mask. So it's a mask that goes over their face and they talk into it, repeating everything that's said. I don't even know if they could read it back to me in real time. I've never thought to ask. Maybe I'll try it sometime and see if they're able to do it.
Well, delivery's all wrong. Butchering it.
That's a real problem that you have. As I said, the transcript is a written document. Before the judge, on like a motion, the judge is going to read it as a part of the materials that are presented to him or her. But the depositions can also be shared with the jury at trial. Sometimes they can just be read aloud by the lawyer or by the witness to the jury, in which case the tone is completely devoid of its original tone. You're sort of at the mercy of the person reading it. For that reason, a lot of times I will have my depositions videotaped. So there'll be a video recording of the witness that I can then use at trial if necessary. Part of that is to catch all the nonverbals, so the witness's appearance, their hand motions, so the jury can assess their truthfulness. But it's also useful in a situation like this when the tone of what was said really matters but may not be captured in the written record.
Did Ms. Levinson ever say why she thought she was being fired?
She thought it had to do with the twins. That's what I call them.
Can you be more specific? Who are the twins?
To be delicate, they hang off Milady's chest. They make milk.
You don't need to go any further. Her breasts.
Yes.
She thought it had something to do with her recent breast enhancement surgery.
Yes, and frankly, the timing was nothing short of predominant.
I don't know what the word predominant means. That's clearly a word that Michael and Jan, or Michael, the lawyer, had talked about before his deposition, and he was trying to find a way to get that word into his deposition. This is why I don't tend to coach my witnesses on what to say, other than telling them, hey, we're just going to tell the truth. Because when you try to feed someone a line, this is what happens. It comes off completely unnatural, and you can tell that they're just sort of trying to insert it.
We disclosed our relationship.
On this wide shot real quick, I want to just talk about who's in the room right now. We've talked about the court reporter who's behind sort of this woman's head. You've got Jan's lawyer, who's the one that's asking questions. Jan, the plaintiff in the case. Then there's this gentleman sort of at the head of the table, and I don't know what his role is. He could be there as a representative of the company, sort of playing the same role as Jan is, but on behalf of the company. But we'll see in a minute that Toby, who is the HR manager, is also in the room. To me, his role in this scene seems to be that of sort of a judge almost. There'll be a dispute in a minute about what to do with making copies of a journal, and he will sort of settle it and say, all right, here's what we're gonna do. To the extent that he's sort of supposed to be taken as some sort of judge or umpire or official in the room. That doesn't happen in my jurisdiction. We don't tend to have anybody in the room whose job it is to resolve or mediate disputes in real time. I have heard of, although I've never done it, you can sometimes, if you have a dispute during a deposition about whether or not a piece of evidence should be marked as an exhibit or whether or not a question's proper, I've heard of lawyers calling a judge on the phone or a magistrate, getting a ruling in real time. I've never heard of that being done in my jurisdiction, though. I think some other jurisdictions do that. That is one thing that if he's supposed to be playing that role, that's not really the way that it works.
Here.
Okay, the company has just a few clarifying questions, Mr. Scott, if that's okay with you.
So this is interesting. We've just seen Jan's lawyer ask a bunch of questions, and now this woman, who's the lawyer for Michael's company, is going to ask questions. In my experience, the lawyer who has what's called noticed the deposition or requested the deposition, that's usually who gets to take the lead in asking questions. Based upon that, it's interesting because Jan's lawyer is asking Michael questions. Michael works for the company that they're suing, and yet Michael kind of seems to be on their side. Clearly, he and Jan are cooperating together. And then on the flip side, you've got this woman who represents Michael's company, so you normally think that Michael's on her side, but she's actually going to have to kind of treat Michael as something of a hostile witness to get the evidence that she needs out in the deposition. So that's just sort of an interesting, weird posture of this deposition. You can have situations where you'll have an individual witness who maybe is an employee of the company, but their interest isn't always exactly aligned with the company's interest.
Taking a quick look at this photograph, please. That is you and Ms. Levinson in Jamaica, is that correct?
Uh-huh.
And that photograph was taken more than 2 months prior to the start of your relationship. Does that sound right? Mr. Scott, the timeline here is actually very important. Please, when did your relationship actually begin?
Well, depends on how you define begin. I mean, if it's from the first time we shook hands, it's like 6 years ago. If it's from the first time we kissed, it's like 2 years ago.
Wait, excuse me?
If it was from the first time we kissed sober, it was like 4 months after that.
One mistake by the lawyer here is when Michael reveals that they have been dating longer than they originally thought, and she says, excuse me? That's a bad move. There's this saying that's don't interrupt your opponent when they're making a mistake. And that's this. That excuse me is going to click off for the witness. Uh-oh, I've just said something I shouldn't, and will give them the opportunity to come back and try to clean it up. The right move here is to go, just like, don't even, just nod and listen. Look at the witness and just, because you're going to encourage them to keep talking, and they're saying stuff that's really bad for the other side's case. You don't want to reveal that what they have just said is really important, because you want them to keep sharing what they're sharing.
Short break?
No, are you telling me that your relationship began 2 years ago and not in February as you previously testified to here?
Jan's lawyer just asked for a short break, and the lawyer for the company said no. That's probably how it would go. I mean, generally speaking, when I'm taking a deposition, I will ask the witness, I'll say, sir, ma'am, we can take a break at any time that you want today. I would just ask that if I've asked you a question, if there's a question on the table, I'd ask that you answer that question before we take a break. Is that okay? And the witness always say yes. And the idea there is, if I have the witness saying stuff that they shouldn't be saying, and the other lawyer is like, can we please take a break? And the other lawyer is doing that so that the witness has time to think before they keep saying stuff they shouldn't be saying. Perhaps the lawyer is going to try to do some coaching of the witness during the break, although they're not supposed to do that. So for that reason, I always say, no, I need the answer to my question first before we can take a break. I want to get the answer to this question. And that's typically how it goes.
Began 2 years ago and not in February as you previously testified to here?
Line.
I'm sorry, what?
He asked for a line, like in a play.
I love Michael asking for a line. That gentleman at the head of the table interrupting, and it's for comedic effect for our benefit as the audience. I get that. That would be improper. Generally speaking, non-witnesses in the deposition that are in the room should not offer anything substantive. Sometimes it can be difficult where I'll be representing a witness during a deposition, and there will be some confusion where the lawyer and the witness are not communicating. They're not on the same page. And it can be very tempting to step in and say, here's what the witness means. But then I'm testifying for the witness, and that's not proper. A lot of times I'll object. I'll say objection. In a deposition, in North Carolina at least, when a lawyer says objection, they're just sort of making that for the record. The witness still answers the objected to question, but that signals to the other lawyer, and if my witness is paying attention to the witness, hey, there's something wrong here. You guys are not on the same page. There's something wrong with your question. Objection. And sometimes they'll key the lawyer in to getting it cleaned up. If the lawyer doesn't clean it up, oftentimes lawyers won't clean it up because they like the misunderstood answer. At the end of the deposition, when it's my turn to ask questions, I can then go back and get clarification on that misunderstanding, that miscommunication, and get it cleaned up.
Mr. Scott, do you realize you just contradicted yourself? I did. Yes, you did. Can I go to the bathroom? No, I really have to. I've been drinking lots of water. You went 5 minutes ago. That wasn't to go to the bathroom. That was to get out of a question. You still have to answer it. First, can I go to the bathroom? No.
I need to go to the bathroom so I can get out of answering this question. I've certainly had witnesses who are uncomfortable with where their questioning is going and want to step out of it. And can I go to the bathroom is a classic move.
Thank you, Mr. Scott. That's all we needed to know.
Wait,
So after the second lawyer is done with their questioning, the first lawyer gets the opportunity to come back. In fact, the lawyers will kind of keep going around and around in a circle until all of them have asked all of their questions. And so it's totally appropriate for Jan's lawyer now to say, actually, based upon that testimony, I have more questions. That happens a lot.
to the record, a page from Michael Scott's personal journal.
Whoa, 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 whoa. What are you doing with my diary?
This is Plaintiff's Exhibit
No.
107.
We're going to need to see a copy of that entire journal before we proceed.
I don't think anyone in this room has a right to read my diary.
It's basic discovery. We have the right to review it.
Her interruption there is right, that we need to see a copy of this entire journal before we're going to proceed. That's generally correct. If you're going to show a witness a document during a deposition and ask them questions about it, the witness needs a copy of the document to be able to look at. The witness's lawyer, if there is one, that's representing the witness themselves, needs a copy of the document. And all the other lawyers in the room need a copy of the document. So typically before a deposition, first of all, bring copies of whatever documents I'm going to use. But even still, I'll often let the other lawyers know, hey, I think I'm going to be looking at the crash report. We'll look at this medical record. We'll look at this portion of the surveillance footage, just so you know. And so everyone kind of comes in knowing what's going to happen. There's not really supposed to be many surprises. When there are surprises, what you'll see happen is what happens, which is it disrupts the proceeding. And we also take a break. And sometimes you have to stop the deposition and then reconvene at a later date, which is inconvenient for everybody.
It's basic discovery. We have the right to review it.
Okay, let's make 10 copies of this diary.
Could you make it 11?
11. Sure.
Person at the head of the table say, let's make 10 copies of this diary so we can all read it. Lawyer for the company says it's basic discovery. We have a right to it. That's probably true because Jan's lawyer has it. If Jan's lawyer didn't already have it, if Michael had it and they wanted to subpoena to get access to it, that's a different procedure than getting it through discovery. And Michael would have a lot stronger grounds to say, no, you don't get this. I'm not a party to this lawsuit. He'd probably lose that argument. He'd probably have to give up his diary anyway. But that's different than the situation here where Jan's lawyer has it. The plaintiff has a copy of it, and so the defense absolutely has a right to have a copy of it. That is, as she said, basic discovery. So that's Michael's deposition from the office. It's a great scene just sort of as a piece of television, but it's also really interesting to watch as a lawyer who is in depositions all the time. So much of what they did in that scene is very accurate. Clearly someone in the writer's room had been in a deposition before or was familiar with that process. They also made some compromises so that they could tell their story, which is to be expected. Hope this video has been interesting to you. If there's any other scenes that you think I should take a look at and sort of break down, please let me know. I'd love to take a look at them and give you my thoughts in real time.